So, Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
okay.
Martin Weinberg. If, in fact, the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached, and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much.
Of course.
Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works, so why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown, and the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be which charges are going to go forward and which are. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
Okay, that sidebar ended up concluding the day, and it seems that they're going to be back, I believe, Thursday now. They pushed it back instead of coming back tomorrow because of, I guess, some scheduling issues that were just brought up by the defense there. So the big one there is that the Karen Reed's team is taking the federal track to the next level, to the First Circuit Court of Appeals, after the federal judge denied their habeas request to eliminate those top 2 charges for trial number 2. So they lost round 1 in the federal system, trying to convince the federal government that this is double jeopardy, that this jury did come to an agreement on not guilty on the top 2 charges. So they want to try Karen Reed the second time around with those 2 charges gone. The state, they exhausted their state resources going all the way up to the state Supreme Court, but the federal track is still an option, and they are pursuing it. The problem is, should this trial be continued while the federal court weighs in? They've expedited the briefing. Both sides will brief this week. But what about a decision? We all know that the wheels of justice turn slowly. This is a massive case. Philip DeBay, this is a bit of a conundrum for Judge Cannoni. What do you propose she does, given all the things that she just outlined too, including the jury selection process, which is well underway for the April trial date and takes months to achieve in terms of jury pools? Your take on what should be done here?
It's not even close. She's going to deny that request to stay or to continue the criminal trial. Federal courts recognize a doctrine called abstention. The abstention doctrine means that federal courts, federal judges, federal magistrates will abstain from getting involved with state court prosecutions by way of delay, continuance, injunctions, etc., until the state court proceedings have resolved on their own in due course. And it's based on this notion of what we call comity, C-O-M-I-T-Y, where there is respect for sovereign nations' courts, sovereign states' courts, fellow jurisdictions' courts, without necessarily involving the federal government. And I think the other reason why, too, is that the lower court clearly denied the request for jeopardy relief. And the reason why is that it's already clearly established precedent by the U.S. Supreme Court that returning a verdict is a term of art. And what that means is that the jury has unanimously reached an agreement, that they have filled out and signed the verdict form, that the verdict gets published in open court and it gets recorded. If you don't have all four of those elements satisfied, you do not have a verdict and it cannot be published, period. It's almost like having a will or a trust that has not been formally executed and signed and witnessed. You have a testator who says, you know, again, I want Aunt Mildred to get the pearls. I want my butcher's best friend to get the pots and pans. I want cousin Shlomo to get the house, that kind of thing. That's all nice and good, and it's all laid out in a rough draft. But absent the final execution and the signatures and the witnessing, you don't have a will. You don't have a trust. And that's what happened with the verdict forms. They literally ended up with blank, rough drafts. No federal court is going to disturb that with the clearly established precedent.
A probate court could give Aunt Mildred the pearls eventually. It's just going to take longer. And the federal government could make a different decision on whether or not this is double jeopardy. We'll see how this plays out. But I agree with you. There's no way Canoni's going to stop this train.